When we were talking a little bit before the show, and I was asking you about your practice. Tell people about what kind of practice you do, the kind of people you help, things like that.
Okay, I'd be happy to.
Sure.
I help individuals, small businesses, entrepreneurs, and medium-sized businesses with their patents, trademarks, and copyright registrations. And branching out a little bit from that, I also have done some work with clients who need a release of intellectual property rights from their employers, which is also kind of challenging and kind of fun. That's pretty much what I've been doing the past several years, as well as patent applications. A lot of people come to my office, and if it's their first time, they really don't, through no fault of their own, of course, really don't have a handle on what they even need to file a patent application. So a significant number of them have to be advised that they need a lot more than an idea, because you cannot patent an idea. You really have to have something that's completely thought out technically. So a lot of people have to do that. On the other hand, I've had a lot of people, they have a complete prototype when they come to the office. And that's the very best possible scenario for me, because then I can really do a very comprehensive description down to measurements of what they need to submit in the application. And
let me interrupt you here for just
sure.
a second. I got about a minute left, but I want you to tell people how important that is about a patent, about you, because you said that it gets me to write that description. Talk about that a little bit.
I'd love to, because this is something where I really like to get on a soapbox. It's impossible to impress on people how important it is to have a written description and drawings, if necessary, in your patent application. For a variety of reasons, the most important of which being under the patent law, you have to have as comprehensive a description in your application as possible. One of the reasons being that the patent application is not any good if you get a rejection from the patent office saying you don't have enough technical information.
Well, let me interrupt you there. We're going to pick this up on the other side, because we're going to have.
Well, I just had one other thing I had to say about it. You have to put that in the initial application, because it's the earlier you get it in, the better it's going to be for you. For a variety of reasons. It's kind of like vote early and often. You have to get it in there early, because you don't know what's up on the horizon, where you're going to need an earlier filing date for a complete description. I've recently read several cases where somebody didn't do that, and the whole house of cards fell down when they filed continuations of the same subject matter. You cannot add to it later if certain deadlines have passed. And that's a lot for someone who isn't a patent attorney to remember and understand. That's part of my job.
I love your reference.
The whole ball of wax.
I love your reference. Vote early, vote often. That's a Chicago.
That's Chicago.
That's
a
Chicago thing. So